There are cases where the government of the day or the party in power will want to unnecessarily, or rather will want to make itself dominant in government, and by so doing find a way to influence other parties to make them weaker as compared to its ruling party. Well, by this we are going to be looking at suppression of dissenting voices in a democracy, addressing legality. My name is Philip Omo. Welcome on board with me. The program is Law and You. And discussing this topic, I have a legal practitioner with me, as we always do, and he is Sonny Daudu. Big thanks for joining, Sonny.
Thank you very much.
Now, let's look at how it has been done, because I believe that, in every society, they have their, uniqueness. And there's this every tendency for the government of the day to want to, continue to sustain itself in power. And we know we have the big one coming up in 2027, the general election. So, but without making reference to any political party or any administration tied to any president, let's look at the role of the Constitution or the provisions of the Constitution as regards protecting the suppression of dissenting voices, protecting dissenting voices from being suppressed. And of course, to what extent can the government limit such dissenting voices that will be seen as constitutional or legal?
Well, thank you. Now, issue of suppression or no suppression of the dissenting voices in politics, I think is the correct decimal. But let us put it in context that the Constitution, especially Section 39 of the 1999 Constitution as amended, guarantees freedom of speech, freedom of information, and freedom of expression. What that simply seems to mean is that every citizen of the country, whether a political party or individuals or groups, have the constitutional right to express their views, opinions, or ideas as they wish. But again, the Constitution places a limitation. That is, there is an extent to which that right guaranteed by the Constitution can be expressed. If it is made in such a way that can ridicule a government, or to ridicule a person, or to bring a person to disrepute, then it could be restricted.
By the government by the law?
By the law. The law is enforced by the government. The law is enforced by the government. So the law also provides restrictions as to the exercise of those rights. So if, for instance, acting in concert with the provision of the Constitution, a person is checked about his statements that are tainted to bring a government down, or to damage the image of a government, damage the image of a person, or bring a person to disrepute, it could be stopped. And such will not amount to suppression of voice. The reason for this is that, apart from the Constitution, there are other statutory or regulatory laws, enactments, laws against libel, defamation. If a statement is calculated to defame the person of another, or to ridicule another, then of course the law will play its role to assure that the person who makes such statements unguided could be checked.
Okay.
So if you also look at the Freedom of Information Act, also give a leeway to seek informations of government. But if informations are not verified before they are altered, just to ridicule a government, then of course the government can rely on the provisions of the law to converse a restriction. So in such situations, it will not be tainted or termed suppression of political voice. But let me go further first. In politics, there is a common sage in the palace that the minority, maybe the dissenting voices now, when you say dissent is term minority.
Yeah.
The dissenting voice is minority. Then the majority, maybe the government in power. So the minority will have their say, but the majority will have their way.
Yeah.
But at all points, at all time and purposes, there must be a nexus between the critique of a minority about the government of the day or about the person in question. If there is no nexus if there's a disconnect, then the excesses of such a person who makes such a statements that are grounded, that are founded, that cannot be substantiated, that are not evidenced, then of course they may amount to either defamatory statement, they may amount to libelous statements, or statements capable of disregarding the provisions of the law itself. And in such situations, the person can be curtailed.
Okay,
it will
thank
not
you.
amount, as I said, will not amount to the suppression of dissenting voices. The reason for this is in a democratic setting.
Yeah.
In a democratic setting, governed by law, citizens are free to express their view, but it's with a permissible limit.
Yeah, it's with a permissible limit. You made mention of the government, trying to quiet such dissenting voices if they seem to be going beyond boundary. But let's look at it, for instance. Doesn't the citizen enjoy the right to take the executive? Because if we say the government this time around, maybe it could be, such powers coming from the executive. Doesn't the citizen enjoy the right to address such issues if executive powers are brought against it in the way that it feels that it's arbitrary or an abuse or infringing on his rights?
Now, where the policies of government are implemented in such a manner that offends the citizens' rights, the citizens have the right, either by way of protest, to protest against the government policies or program that is unfavorable to them.
But we've seen situations where governments, try to quiet the protests.
Now,
do you see that as constitutional?
The thing is that at all time, any protest that will be backed upon, permission may also be sought. The reason for that is that the Constitution, for instance, vested powers on the governor or the executive to be responsible for the security architecture of the state. Therefore, the agency of government, for instance, the police force or the security architecture, must be put on notice that the citizens of the state are disenchanted with a particular policy of government which they term favorable.
You said put on notice, not seeking approval.
You put on notice, that's an approval. Once you write, is seeking approval. You put on notice, is giving a notice to the police to provide security. It's not just a notice without a request for protection of security.
There's something different if you want to analyze that.
No, there's
something different from putting on notice.
Yes,
and
when
of course,
you put on notice,
seeking an approval.
No, what
because you are just giving a notice that your group,
what the Constitution
you are embarking on a protest.
Yes,
and that the security should give you a cover, protection.
Yes,
it's quite different from asking for an approval.
It's an approval
to
for instance
on such a protest.
The reason
because. Are you by this saying that even after that notice has been given, the police have the wherewithal
to refuse,
either accept or refuse?
Yes, I will give you this. I will give you that. That's why I say it's similar to approval.
Okay.
The reason is that the security architecture and the information available to the security may not permit a protest at a particular time. If they believe that that protest may be hijacked and that there were already other issues yet to be addressed, you cannot add protest, that is public protest to that, until that situation has been arrested.
You are saying if they believe that protest can be hijacked. Is that not the reason why they are asking for such security?
No,
is that not why you are putting that protest
what
on
I'm
notice?
saying in essence
putting
is that
police on notice that at least you should give us some cover. Because if the police or the law enforcement agents are having this impression that it may be hijacked, that gives a better reason to give that protest some protection.
No.
So that it doesn't, escalate.
If a system is already being fueled by some escalating or unaddressed issues, then there is a notice of protest. The government or the security agency may give a security advice that this protest is untimely because of this current issue. Let's take, for instance, let me just give you an instance. Assuming, for instance, the president of the country wants to come to Edo State today, and protesters from Benin City have written to the commissioner of police they want to protest. The commissioner of police will not grant it, because it's not a forum convenient for a protest at that point, because the security of the president of the entire country is at stake. So the government or the security agency may shift it to the protest, may not give approval for the protest, may give reasons why the protest should we hold at this time? Allow the president to come and go. Then you do your protest. That's why I'm saying that there are, assume, let's take another. Let's say election will be held this Saturday. Our citizens have written a letter, we want to protest today that is election. The government, the police will not grant it. So there are situations where the notice will not be approved because of the similar situation, circumstances on ground. Or if there is a security information that there may be an escalation of maybe clash of interest, maybe courtesan and all of that, which the security have deployed their men to such area, and then you forward a letter to the commissioner of police, approve a protest for me for this day, they may not approve it. So these situations does not stop the exercise of the right. But it's just that at that time they are not ripe, they are not mature to exercising or expressing those issues. So more often than not, the police need to be, or the permission of the police need to be sought and obtained.
All right.
And giving credence or giving approval to that is based on the circumstances, the prevailing circumstances on ground. So that is the reason why if you now violate, if a person now go on the street to protest where approval was rejected or grounds of other circumstances, in situations such as that, the government or the police can use minimal force to restrain the protest. And if that is done, it is not suppression of dissenting voices. Okay. It can also effect arrest. They may also deploy the use of gas to suppress the protest.
Okay.
In such situations, the Constitution provides for all of this. It is not a breach of the Constitution. It is legal. It is not to suppress it, but to ensure the constitutional sustenance of security architecture of the state.
Okay, but it's like you said, like in what is already in public domain, the citizens can take the government to court.
Of course.
And even if such actions are leveled against such a group or such a person from protesting, and he or she feels aggrieved, or the group feels aggrieved, it can also address it before the
very
law.
Well, very well.
Okay.
Very
now,
well.
Let's also look at situations, situation where, for instance, we are gradually delving into the general elections coming 2027. And, politicians are always looking at the next, election and saying how to walk towards it. A situation where a governor of a state, for instance, without making mention of the name or the state, demands that or refuses a political figure or another politician from campaigning in the state. Do you see that as an act of suppressing dissenting voices?
It is uncultured. It is unallowed in a democratic setting. It is even misguided advice to the government of the day. For instance, a person wants to use a public place.
Yeah.
Then you say you can't use it. It is even depriving the state of the resources of that revenue to be generated from such gathering. For instance, if a political party other than the ruling party, for instance, want to come and campaign in a do, it will generate revenue. Why will you stop them? Hotels, accommodations, first, transportation, people will benefit. The public place that don't go to utilize, they are going to charge a revenue, because the reason why you charge is if the facilities there are destroyed, you will be able to plow back or what you collected from them to repair those things back.
All right.
It will generate resources. It is government that are ill-advised. That, for instance, a big political party want to come and campaign and do, you say no. They are ill-advised.
All right. The program is Law and You, just in case you're just coming across it. It's Law and You, and we are on the topic suppression of dissenting voices in a democracy, addressing legality. And I've been speaking with a legal practitioner in the person of Barrister Sonny Daudu. I am Philip Omo Gyukwan. We'll take a short break. After we will continue with this discussion. Do stay. Thank you for joining us. The program is Law and You. And I still have my guest with me, Sonny Daudu. Now, we've seen situations where, there's this, if it's fear of insecurity, I can tell, because there's this fear that maybe a governor of a state may not want a very huge political figure to come into the state and probably the fear that when the person comes into the state, the person could use his influence, to canvass votes against his party. At what point can you say such a governor can be right to stop such a political figure from coming into the state for it not to disturb the calculations of each party in winning elections?
Well, there's only one point that a governor may be right, where, for instance, the governor is not notified as the chief security officer of the state that that kind of political movement is coming to a state.
Okay.
Then the governor at that point will be right to refuse such entry into his state, because he protects the territorial sovereignty of the state. Apart from this, no governor that has any power under the Constitution to restrain or restrict the movement of any political bigwig in the country, for whatever reason. It's only when on ground where the state was not notified, the governor was not notified. If you neglect the power of the governor of a state, if you don't respect the powers of the governor of a state, then you cannot come to a state. More often than not also, what is even permissible in civilized crime is that any political gathering, you must go, first of all, go to the state. Go to the governor, you greet the governor. People will have a picture, you talk, I'm in your state. You will go and do his campaign. What government should be taking off is development and not restriction of people from campaigns in their state. When you have developed your state, a person comes to the state, he has nothing to campaign with for himself. If you want to talk about roads, you have done roads, there are roads. Talk about schools, there are schools. Talk about infrastructure, transportation, there is transportation. What's he going to campaign with? What's he going to campaign with?
Okay.
So, government should concentrate on development and not campaigns. Once you are a government, your work will speak for you. The development in the state will speak for you. When Adam Osomole was in power, he didn't need campaign in second tenure. Because the work is his first tenure, we're speaking for him. And the nooks are crannies. So what government should do, instead of restricting people from campaigning in their state, is to allow when the person enters your state, this speaks volumes of what you have done in the state. And not situations where you think by preventing a person from entering your state is what will protect the votes for you. No, it's development.
Okay,
it's development.
Can you tell us what legal remedies exist for those who have been victims of this
there are legal remedies. Because as I said, there is freedom of movement guaranteed by the Constitution. If a person feels and believes strongly so that his freedom of movement
was
infringed upon or tampered with by any constituted authority of government, including agencies of government, the person can leverage on the instrumentality of the law and set the law in motion against the person in a competent court of law to seek redress. You cannot restrict the movement of any person, provided, of course, it is within the permissible limit of the law, as I mentioned earlier. You can't restrict it. But if a person feels that his freedom of movement has been tampered with by any government, he can leverage that in court of law, and the court will provide remedies. It's in form of damages.
Okay, but we've seen this happen every day. Situations where citizens feel that the government is, coercing or infringing on their rights. But again, we have this political immunity that the governor has. So, at what point can you say who will the citizen be taken to court?
No, for instance,
is it the state government?
Is the governor? Is the state government, because the governor represents the government.
Okay.
You can sue the governor.
Okay, but how do you explain political immunity in that case?
No, the political immunity does not. The government does not have political immunity. The government of Edo State does not have political immunity. You join the Attorney General of the state, who is the law officer. Because if the law of the rights of citizens are breached, they are deemed to have been breached through the office of the Attorney General of the state. So the Attorney General will be joined as an interested party. You sue the state, you join the Attorney General of the state.
Okay.
In enforcing the violation of the citizen's rights, or any person who feels that his right has been violated, the government can be sued. It's only the governor that cannot sue in person. You can even sue the name of the governor, as in governor of Edo State, without including his name. It's his name you cannot include. For instance, now you cannot say you are suing Upebolo.
No, but the office.
The office of the governor of Edo. You can sue the governor of Edo State as a party. Governor of Edo 1, Attorney General of the state 2.
Have you seen cases where such litigations go through and their citizens win?
Of course. No, of course, there are.
Okay.
There are plethora of decisions of the court that that are not publicized. Several decisions of the court. There are even actions of taking a government while the government is here. For instance, where a governor maybe uses his pen, the left hand of his right, to dismiss his staff. The staff goes to court against him. Why is he in government? Why is he still in government? He's restated back. He doesn't enjoy such immunity. You sue the government as in governor of Edo State, not including his name, because it's his name that has immunity because of the office he occupies.
Yeah.
But that office does not have immunity. You can sue the governor of a state. If for instance, maybe a person who was perceived to have supported an opposition political party during the elections, the governor comes in and says, send me their names. He uses his left hand to sack them. They don't need to wait till he leaves government before they can sue the governor. They will see him. But not in person, but in the office of the governor of the state. And sue the government too. The government of Edo State. Join the Attorney General. And also add the commission. Maybe the Civil Service Commission. Or any other commission. Maybe the Judicial Service Commission. Or any other commission. Or the Local Government Service Commission. Any other commission that was also responsible for DASA can be joined as parties. So there are plethora of cases that citizens have won against government that does not maybe catch the attention of the media, because media may not be able to cover all the cases that are going on in courts. Except again, a citizen cannot also preempt, or a litigant cannot also preempt the judgment of the court to say, come to court today and go to win so that you can air it that I defeated the state government. You can't preempt. You cannot be too sure of what the decision of the court can be.
Okay, but like they say, delayed justice could be tantamount to denied justice. Now, a situation where some suffer challenges where they have cases in court, and then it amounts to like waste of time, and probably as if the government of the day is trying to play with time to make sure that such a person does not get justice. How should the law address such cases? Are they not time bound?
Yes.
At which cases can be prosecuted?
Very well. The Constitution have deepened seeking of legal redress, especially, of course, when it affects human rights. There's what is now called fundamental human right enforcement. It doesn't take more than a year.
Oh.
Fundamental human right enforcement is brought through what they call originating summons. You don't call witnesses. It's just to look at the provisions of the law and say that this provision was violated, and you give distances how it was violated. You don't need to call witnesses. There are no more adjournments.
You don't need to call witnesses.
No, they don't call witnesses.
It's different from the electoral.
It's different from the electoral.
Yeah, because the one that we
it's different.
Just now,
once
shows that if you have evidences, then you have to call witnesses to it. Because sometimes you wonder, but this is an electoral act. This is what it states, that this is against the provision, and it's in black and white.
Yes.
But you now expect somebody to prove it beyond all this.
No, let me tell you.
So why that difference? Why that difference?
There's a difference. For instance, when the right of a citizen is violated, the Constitution has now streamlined it. A man cannot be complaining that you have violated his right, and you keep the enforcement for 10 years, 10, 20 years. It will defeat the justice, because as you said earlier, justice delayed is justice denied. So there is a strict procedure for fundamental human rights enforcement. So all you need to do
specifically
for that to enforce
not election matters.
Not election matters. Election matters are sui generis. I will come to that.
Okay.
Now, once your rights are violated, you file fundamental human rights enforcement in the court of law and state the provisions of the law that the person violated.
And it mustn't exceed a year.
In some cases, it doesn't have to get to 6 months.
Okay.
It doesn't. The fundamental human rights enforcement.
What about if the courts are full of cases?
No. Fundamental human rights enforcement is taken as primary interpreters in terms of matters in court.
Meaning?
They are taken so quickly.
Okay.
What it means, they are regarded first among equals.
Okay.
Because it's human rights. Assuming, for instance, somebody is detained in the prison or detained in the cell. You don't keep him there. The court will expedite the
speed up such a case.
So within, maybe adjournments will not be 2 weeks, or at most 1 month.
Okay.
So in 2 or 3 adjournments, judgment is given, one way or the other, whether or not the rights of the person.
Okay.
Because here, the court merely interprets the provisions of the law, whether or not, of course, these circumstances amount to violation of the person's right. Now, let me go to issue of elections.
Barrister Sonny, I think we're going to spill this to the next episode so that we can finish strong on that. Big thanks, Barrister Sonny,
Thank you very much
for taking our time to be part of this. This is much we can take on Law and You. I see you on the next episode. Bye for now.